Hello, everyone, and welcome to this month's webinar on sexual orientation and gender identity in the workplace. This free webinar is available exclusively for our compliance management subscription customers. I'm Robert Leland, the Director of Research and Product Development for Personnel Concepts, and I'm joined by my co-moderator, Kim Cabanting, who is our Managing Editor.
Hello, everyone. Today's speaker is Jessica M. Merle, an international attorney barred in the states of Illinois, Georgia, and Washington, D.C. Before launching her own practice, Jessica served as the Tender and Defense Counsel for the southeastern United States for Home Depot, providing her with extensive experience in litigation and legal consulting. Her current focus includes serving as general counsel to small and mid-sized clients with a focus on the areas of employment law, corporate consulting, and business development and transactional law. She currently spends a large part of her time in the Netherlands, the first country in the world to recognize a right to same-sex marriage, which is our topic for today's webinar. Thank you, Jessica, for joining us today.
Thank you for having me. I'm excited to discuss this topic with you and our audience today.
So we initially selected sexual orientation and gender identity in the workplace as today's topic due to the recent legal developments, increased focus from enforcing government agencies, and increased national awareness of LGBT issues. In the last few years, we've seen the rise of same-sex marriage and its subsequent impact on the workplace, as well as guidance from the Equal Employment Opportunity Commission on the applicability of Title VII's existing provisions regarding claims of discrimination based on gender identity and sexual orientation. We've also seen new guidance from OSHA and various states on restroom policies for transgender workers.
Now, the format for today's webinar features a series of questions that Kim and I will be asking to Jessica regarding sexual orientation and gender identity in the workplace. Before we begin, I want to invite everyone in attendance to submit any questions you may have during the presentation by using the Ask Question feature in GoToWebinar. You can also pose questions in the chat window. Most questions will be saved for the end of today's session, but those that are relevant to the subtopic being discussed will be posed where appropriate. At the end of the session, you will have an opportunity to use the Raise Hand feature in GoToWebinar to pose a question directly to our guest speaker. Now, we recognize that gender identity and sexual orientation are sensitive, divisive, and controversial topics for many Americans. All of our presenters today, myself included, will make every effort to avoid using any insensitive language or stating any personal opinions about the subject matter. We also respectfully ask that you use similar discretion if you are given an opportunity to pose a question to our guest speaker. With that, let's get started with today's presentation. Kim?
Now, Jessica, we mentioned in the introduction that the legalization of same-sex marriage has created new and emerging issues in the workplace. How did last year's Supreme Court decision bring LGBT discrimination issues to the forefront of workplace discrimination law?
Well, Kim, last summer, the United States became the 14th country in the world to recognize a right to gay marriage, with the Supreme Court's monumental ruling in Obergefell versus Hodges. The court's decision in that case is sure to stand alongside other monumental civil rights cases, such as Brown versus Board of Education, and we foresee that it will forever impact the employment law landscape as it relates to lesbian, gay, bisexual, and transgender rights, which I will refer to as LGBT rights throughout the seminar. The Supreme Court's ruling was not unexpected for most people who have followed the development of civil rights laws related to LGBT issues over the last 20 to 30 years. Since the Supreme Court's ruling in the matter of Price Waterhouse versus Hopkins in 1989, courts nationwide have been moving towards recognizing sexual orientation as a fundamental civil right. In Price Waterhouse, the Supreme Court first held that discrimination based on gender violated Title VII of the Civil Rights Act. A decade later, the Supreme Court recognized that same-sex sexual harassment was a violation of Title VII as well, and starting in the 2000s, LGBT matters were some of the most widely publicized cases, with courts across the country considering issues related to same-sex marriage, sexual orientation, and transgender rights. Perhaps most memorable among these cases was Lawrence versus Texas, in which the Supreme Court struck down Texas's sodomy laws, making homosexual activity legal across the country. Very recently, the LGBT movement has had even more momentum added, with the first widespread public recognition of a transgender celebrity, when Olympic athlete Caitlyn Jenner, formerly known as Bruce Jenner, made headlines when her transition to a woman was highly publicized through television pieces and a Vanity Fair magazine cover last year. Thus, the Supreme Court's 2015 ruling in Obergefell was the natural conclusion to the moment that had been building behind LGBT rights for the last several decades.
Jessica, the Supreme Court's ruling on same-sex marriage has also created a wave of reactionary legislation at the state level. How did lawmakers at the state level respond to the Supreme Court's decision?
Naturally, the Supreme Court's ruling and public acceptance of a transgendered person infuriated many lawmakers and their constituents. This led to more than 115 anti-LGBT rights bills being introduced in state legislatures across the country last year alone. Though the proposed bills largely failed, some passed as well. Most notable among these was in North Carolina, which in late March of this year passed the Public Facilities Privacy and Security Act. The result of North Carolina's bill, as we'll discuss later in this webinar, serves to restrict persons to using the restroom of their birth gender, regardless of with whichever gender they in fact identify. This wave of litigation and media highlights has left many employers confused as to the requirements placed on them by the rapidly changing laws surrounding LGBT rights. Though they want to be compliant, we see that many employers are unsure of the way the Supreme Court's ruling and their own state laws impact their employment policies when hiring, employing, and terminating persons who identify as homosexual, bisexual, or transgender.
Those familiar with the term LGBT know that it stands for lesbian, gay, bisexual, or transgender. The LGBT community also uses other specific terminology to describe someone's orientation or gender identity. Based on your research into case law, what other terms could an employer encounter in the workplace?
Robert, you are correct. There are many terms that the LGBT community uses that employers may never have heard of and which may be very confusing to someone not in the LGBT community. In addition to lesbian, gay, bisexual, and transgender, which many of us are already familiar with, some of the more common terms that employers may come across include terms that are related to sexual orientation, such as asexual, meaning persons who have a lack of sexual attraction to any gender, pansexual, which means people who are not attracted to a person based on gender, but rather are attracted to a person based on other intrinsic qualities. There are terms that are related to gender identity with which employers may not be familiar. These include biological gender, which means the gender a person was born with, cisgender, which means a person who identifies with his or her biological gender. So, for example, a man who was born male identifies as being a male. We have the term gender fluid, which means a person whose gender identity changes based on time, circumstance, and situations. There's gender queer, which is a person who identifies as being neither male nor female, but rather identifies as being a different gender altogether. Agender means a person who identifies as being genderless. Pangender is a person whose gender identity is comprised of many genders. And last, bigender, meaning a person who feels two different genders in the same body at one time.
So we touched on the EEOC stance on LGBT discrimination a bit earlier. Some employers might be wondering if this is a new law or if the EEOC is using existing law to back their current enforcement strategy. Could you explain the EEOC's current interpretation?
Absolutely, Kim. One question that employers frequently have is whether homosexuality or transgender status is a protected class under Title VII. Although the short answer is no, the reality is that homosexuality and transgender status have become somewhat a de facto protected class by extension of the law regarding sex-based discrimination. As a reminder to the employers listening in, Title VII prohibits discrimination based on several classes or categories of people. These protected classes include race, color, religion, national origin, sex, family status, for example, being single, married, or widowed. And then in addition to Title VII, we have some other protected classes that have been granted this protected status through other federal laws. These include age, pregnancy, citizenship, disability, veteran or military status, and genetic information, such as a health insurance carrier who refuses to insure a woman because she has tested positive for an increased likelihood of getting breast cancer. As you may have noticed, I did not just list sexual orientation or gender identity as a protected class amongst those that I just provided. Title VII does, however, prohibit discrimination in the workplace based on sex or gender, which is a protected class. In 2002, the EEOC first began recognizing discrimination based on sexual orientation when it found that transgender discrimination amounts to gender-based discrimination for federal contractors. In 2015, the EEOC issued two further formal opinions that made very clear the Commission's stance on sexual orientation and gender identity for private employers as well. In short, the EEOC found that discrimination against LGBT individuals is in fact sex-based discrimination or gender-based discrimination and thus violates Title VII. The EEOC has implemented these stances to obtain more than $6.4 million in restitution for LGBT individuals since data collection began in 2013. Some example cases that the EEOC has considered and has obtained judgment on include a matter where an employer fired an employee who planned to have sexual reassignment surgery, a matter where an employer failed to use a transgender person's preferred name and pronoun. For example, where an employer continued to call a biological male by a female pronoun or name, where an employee was denied a job promotion because of that employee's sexual orientation as either gay or straight. It's important to remember for those employers listening in that reverse sexual discrimination can happen too. So denying a job promotion because of orientation as straight can also come into play here. There was a case where there existed a hostile work environment where employees were subject to anti-gay slings, or where a lesbian employee, for example, was told, quote, "you would look good in a dress." The EEOC considered a case where an employer refused to revise employment records to change an employee's name, and where the employee identified as in fact being a different gender or having a different name. And there was another case that the EEOC considered where an employer refused to hire a job candidate because she was a transgendered woman. The EEOC continues to file and to fight cases on individuals' behalf on such issues, and in fact, as recently as just last month, had filed 2 new cases with similar fact patterns as those I just discussed.
Now, before we proceed, I did receive a question from an audience member indicating that they're having a little bit of trouble hearing you. I don't think that's true for everyone, but what I want to remind the audience is that we are recording this webinar. Jessica's voice sounds very clear on the recording, and we'll be able to send that to everyone at the conclusion of today's presentation. Moving on, with the EEOC appearing wholly committed to prosecuting cases of LGBT discrimination, what are the corresponding implications for businesses? Specifically, what should businesses do and what should they avoid doing as it relates to this issue?
It is very clear that employers should be wary of discriminating against or even appearing to discriminate against job candidates and employees based on sexual orientation or gender identity. Employers wanting to avoid appearing to do so should consider implementing new or revising their old hiring, retention, termination, and workplace policies that already should be prohibiting discrimination against individuals. Some ways that we can revise these policies would include prohibiting discrimination against individuals who are gay, lesbian, bisexual, asexual, or identify under any of those other terms that we discussed earlier. Also, employers can consider implementing new or revised policies that prohibit discrimination against individuals who act outside of traditional gender norms. For example, a man who crochets or a woman who rides motorcycles. Revised policies can include prohibiting discrimination against individuals who identify as genderqueer, including but not limited to identifying as transgender, bigender, pangender, or again, any of those other gender identity terms that we previously discussed. New policies can include prohibiting discrimination against individuals who have had or who plan to have sexual reassignment surgery, or individuals who are in a relationship or a marriage with someone of the same sex. And finally, it's important for employers to note that they should also remember to not reverse discriminate against employees who are straight or job candidates, for example, who are non-transgender, as well as other employees.
Jessica, we briefly touched on restroom access policies. Can you explain what the core issue is and why new laws and new agency guidelines have emerged to address this topic?
Absolutely, Ken. Many employers may have seen the media attention surrounding the boycott Target movement over the last few weeks, or in fact may have seen the media attention in the news just from Monday of this week regarding the lawsuit that was filed over North Carolina's bathroom bill. The movement for the boycott Target issue arises directly from Target's restroom access policies for transgender people. Since the end of the Jim Crow era of racial separation, most people take access to a safe restroom space at work for granted. However, when a workplace has a transgendered employee, restroom access for that person is oftentimes highly stressful, both for the transgendered person and for the non-transgendered employees alike. On one hand, non-transgendered employees may feel uncomfortable using facilities with transgendered people, especially if those people have not fully transitioned. Where for transgendered people, using the facilities of the same sex that they were born into or of their biological sex can make them a prime target for assault and also for health issues when they simply avoid using a restroom altogether. As is happening in the Target example, other people ignore the transgender issue altogether and instead argue that allowing a person that's a biological male to enter a female restroom is placing females at danger of sexual assault.
Jessica, how are state legislatures responding to the transgender restroom access issue? You mentioned North Carolina already.
I did, and in fact, as I also mentioned, more than 115 anti-LGBT bills were introduced in 2015. The majority of these bills were based on religious freedom claims, such as the Georgia Religious Freedom Bill, which was swiftly vetoed after Hollywood threatened to take the filming of its hit shows, such as The Walking Dead, elsewhere. Religious freedom legislation aside, some conservative states are now currently considering so-called bathroom bills, which would make it mandatory for persons to use the public restroom facilities of the sex that's listed on their birth certificates. Most notable among these is North Carolina, as you mentioned, Robert. And as I mentioned earlier, it recently passed the Public Facilities Privacy and Security Act. Though this act is innocuously named, the effect of it is to directly allow discrimination against transgender people. 10 other states are currently considering similar anti-transgender legislation, including Kansas, where legislation aimed at university students would include a $2,500 payday to anyone who proves a transgendered person used the, quote, wrong bathroom. It is too early to know whether such state legislation will withstand scrutiny by the courts, but even if it will manage to pass the state legislations. On the other side of the spectrum is Seattle's 2016 ordinance, which requires that all single occupancy public restrooms be gender neutral. Similar ordinances are in effect in Philadelphia, Portland, counties in Oregon, Evanston, Illinois, Austin, Texas, Washington, D.C., and the city of West Hollywood. It is important to note that much of this new legislation focuses on public facilities, leaving many private employers confused as to what they can and cannot do when providing or restricting restroom access to transgendered persons and employees. The optimum solution may be for workplaces to have unisex, single bathrooms, so that all employees may have the opportunity to utilize gender-neutral facilities. However, for many employers, such facilities may not be readily available or even feasible.
Has the EEOC issued any guidance or opinions on restroom access policies?
It has. Instead of asking employers to balance these issues on their own, last year the EEOC tackled this delicate issue in a case involving the U.S. Army. In that case, the EEOC was asked to determine whether the Army's denial of access to the women's restroom was discriminatory against a transgendered woman. I'm going to read a portion of the EEOC's finding for the employers listening in, as it makes it very clear what the Commission's stance is and is very important for all employers to hear. The EEOC said, quote, "Nothing in Title VII makes any medical procedure a prerequisite for equal opportunity for transgender individuals or anyone else. An agency may not condition access to facilities or to other terms, conditions, or privileges of employment on the completion of certain medical steps that the agency itself has unilaterally determined will somehow prove the bona fides of the individual's gender identity. On this record, there is no cause to question that the plaintiff, who is assigned the sex of male at birth but identifies as female, is female. And certainly where, as here, a transgender female has notified her employer that she has begun living and working full-time as a woman, the agency must allow her access to the women's restrooms. Given this language, the EEOC's stance on restroom access should be clear to all employers. Transgendered, and in fact all, persons must be allowed to use the restroom of their choice. I also want to take a minute to note that though we frequently talk about this in terms of restroom access, the EEOC stance applies to other facilities as well, such as changing rooms, to locker rooms, shower facilities, break rooms. In short, it applies to any facility where the genders are divided.
Do any states have specific laws granting equal access to restrooms for employees?
Yes. In fact, several states have adopted legislation or guidance standards requiring equal access to restroom facilities for private employees, where the access may be more or less restrictive than the EEOC's regulations. Specifically, the states of Washington, Colorado, Iowa, Vermont, and Delaware all have specific requirements for private employers. Similar requirements also exist in Washington, D.C.
Now, some employers may not know that the Occupational Safety and Health Administration, or OSHA, enforces a sanitation standard that requires providing restrooms to employees. What does OSHA have to say about restroom access for transgender workers?
OSHA has issued a best practice set of guidelines for employers to further assist with navigating these issues. Underlying the OSHA guidelines is the idea that a person should be able to decide for himself or for herself which restroom to use based on his or her own gender identity. The best practice tips from OSHA include the following: providing single occupancy gender neutral or unisex facilities, providing multiple occupant gender neutral restroom facilities that have lockable single occupant stalls, not requiring any medical or legal documentation that shows an individual has undergone reassignment surgery or has an official transgender status, and not requiring that the person use separate facilities altogether, which would have the effect of singling out that person. Also, OSHA has that the employers who have any questions at all about implementing gender-neutral or non-discriminatory restroom facilities for their own employers can contact OSHA at their nearest regional office for further assistance.
Jessica, we did get a relevant question from a member of the audience pertaining to bathroom issues or access.
Mm-hmm.
The question from Sandra is, do the bathroom issues apply to private universities?
Well, that's a good question. And in fact, actually, this isn't a private university, but if you've been following the news as it pertains to North Carolina and what's going on there, at the heart of that's going on the litigation that was filed on Monday is that the North Carolina University is contesting whether or not it has to, or if it can, completely ignore North Carolina's ruling and simply implement the federal guidelines, right? So provide transgender people access to the restroom of their choosing. Now, whether it applies for a private university, the answer is probably yes, but again, you need to consult whatever the applicable rules for your state are, as the states may have statutes and may have guidance that's been issued that says whether or not these rules will apply to specific types of employers and, for example, to private universities. But the answer is yes, probably.
Now, before I go on to the next question, Jessica, just wanted to remind everyone again, if you're having issues hearing Jessica, if her connection is breaking in and out, she does sound very clear on our end, and we are recording the webinar, and we will send it out to the entire audience. Jessica, a lot of what we've covered today so far applies to private workplaces. Are there any special requirements for federal contractors?
There are. As I mentioned earlier, employers with federal contracts have actually been prohibited from discriminating against employees based on sexual orientation since 2014. So since before the guidelines came into place for private employers. In 2015, the EEOC was busy implementing this rule for federal contractors, and in fact, it considered 20 federal sector cases. Most notably, these cases included finding that gender identity-related complaints and sexual orientation discrimination-related complaints could be brought under Title VII through the federal sector complaint process. The EEOC also established an LGBT work group to further its adjudicatory and oversight responsibilities into this developing area, specifically for federal contractors. The new rules apply to all federal contracts that have been entered into or that have been modified after April 8th of 2015. They require that employers with federal contracts not discriminate against persons on the basis of sexual orientation or on the basis of sexual identity. They require that employers with federal contracts take affirmative action to ensure that all applicants and employees are treated equally, regardless of sexual orientation or gender identity. And they require that employers include now sexual orientation and gender identity in the employer's equal employment clause in their job solicitations and advertisements. So for the employers listening in, a sample equal employment opportunity clause may now read along the lines of, quote, XYZ company is an equal employment opportunity employer. The policy of XYZ company is to provide equal employment opportunity to all applicants and employees without regard to sex, gender, sexual orientation, or gender identity, pregnancy, race, color, age, religion, disability, national origin, military status, veteran status, or any other legally protected status. XYZ company complies with all state, federal, and local laws regarding employment. This policy applies to all personnel actions, including recruitment, selection, hiring, training, compensation, benefits, transfers, and promotions. The new rules also require that federal contractors ensure equal facilities, again, for restrooms, for shower areas, locker rooms, etc., and that they're provided as we previously discussed. Importantly, the new regulations for federal contractors do not require any changes in affirmative action reporting or data collection requirements. UCLA's School of Law think tank, the Williams Institute, has published a very helpful set of model employment practices and policies for federal contractors related to sexual orientation and gender identity. And I encourage every employer who does work on federal contracts to read and consider implementing those policies and those guidelines. And in fact, I think we have put a link in the presentation, or we'll be emailing out a link to that publication that the Williams Institute has done. I'd encourage all employers listening in to take a look at it.
We started today's presentation with the Supreme Court's ruling on same-sex marriage. Since many health benefit plans offer coverage to spouses, how has the Supreme Court's ruling affected spousal benefits?
The ruling has actually made this area a little bit easier for employers to navigate. Some employers may have actually seen the 2015 film Freeheld, which stars Ellen Page and Julianne Moore, and in which a terminally ill New Jersey police lieutenant takes on the city council to ensure that her police pension could go to her same-sex spouse. If you haven't seen the movie, cover your ears so that the end is not ruined for you. In this movie, which was set in 2005, Moore's character had a long fight to ensure that her benefits could go to her partner. Had the same situation occurred a decade later and in the private employment sector, Hollywood would have actually probably been one film short, as last year's recognition of marriage for same-sex couples all but ended this argument over workplace benefits. Policies must now include, under the definition of a spouse, eligible for benefits, same-sex spouses, which would include benefits for health, retirement, and pension plans, as well as COBRA plans. For many employers, this change in the law may have had the unforeseen benefit of allowing them to now actually drop domestic partner benefits programs and policies that were previously implicitly aimed at providing benefits to same-sex partners, but where doing so could reverse discriminate against opposite-sex couples who received differing benefits packages.
What about other benefits such as family leave? Are these now extended to same-sex spouses?
Yes, they are. Employers who provide paid time off pursuant to either their own policies or those mandated by the federal government or, in some circumstances, state legislation, such as the Family and Medical Leave Act or California's Family Rights Act, must now take special care to ensure that same-sex partners are included in the definition of a family member or in the definition of a spouse for whom an employee may be eligible to take paid time off to care for or to assist.
Now, a lot of what we've covered today focuses on federal law, but discrimination laws can vary by state. Can you explain the interaction between state and federal laws on this topic?
Sure. Many states have their own laws that impact employers. While states can no longer refuse to recognize a same-sex marriage, some states are seeking to restrict LGBT rights in other ways, such as through the bathroom bills that we discussed, or through claims that hiring gay or transgendered employees violate a private employer's rights to religious freedom. What's important to remember is that a state law cannot be more broad or more narrow than a federal law on the topic. So an easy example for this is minimum wage. A state can make the minimum wage higher than what the federal minimum wage is, but it cannot set the minimum wage in that state lower than the federal minimum wage. The same principle applies for discrimination. The state can make more things discriminatory, but it cannot, in fact, allow more discrimination, at least not directly. Thus, it is important to note that regardless of a state's laws, the EEOC's prohibitions against sex discrimination still would take precedence and should control employers' actions when evaluating LGBT issues. Now, not all states are seeking to restrict LGBT rights, of course, with some states and some cities passing legislation to provide even more equality to LGBT persons, as we discussed. These would include Seattle and its mandate to provide gender-neutral bathrooms. Thus, employers must take extra caution to stay on top of their state's laws in this area over, I would say, the next 2 to 3 years, so as to adapt to any further changes that may happen.
Now, Jessica, you mentioned earlier that employers need to adjust specific policies and hiring practices based on these recent trends. Can you provide any specific tips or recommendations to our audience to help them avoid legal issues regarding sexual orientation or gender identity in the workplace?
Yes, absolutely. There are several things that every employer can do right now to ensure compliance. 5 of the most important ones I would suggest include First, revisiting and rewriting, if necessary, your handbooks and policies regarding discrimination and harassment to make it very clear to your employees, to your hiring committees and your administrators that discrimination based on sexual orientation or on gender identity simply will not be tolerated. Second, employers can review and again, if necessary, revise PTO policies, revise healthcare plans, retirement plans, pension plans, and other benefits to ensure that they apply equally to all spouses, regardless of the gender of either spouse. Employers can consider putting together a gender transition policy to walk a transitioning employee and HR through the transition period. Such a policy might include implementing the name and pronoun that the employee prefers, how and when to notify the employee's coworkers, and steps for updating the employee's records and files, among other considerations. Fourthly, employers may wish to establish written guidelines concerning the use of shared bathroom facilities. If possible, they may wish to consider implementing gender-neutral bathroom facilities, but if that is not feasible, at least ensure that all bathrooms have lockable single-use stalls and allow employees to use the restroom of the gender that corresponds to his or her own gender identity. Finally, as always, an employer's best line of defense is to consult a labor and employment attorney in that employer's state, to consult with the EEOC, and to consult with OSHA with any questions, comments, or concerns about the application of the new amendments or of a state statute and their interplay with existing federal and state labor laws.
Thank you, Jessica, for reviewing this information with us. Before we end the session, let's take a moment to answer some questions from our audience that were submitted during the presentation. Robert will ask the questions on behalf of our attendees.
Jessica, the first question is from a user by the name of Aaron. What do employers do if they have less than 15 employees and they're in a state that doesn't have any specific prohibition against discrimination on the basis of sexual orientation and gender identity? Should a business with less than 15 employees still have to comply with the EEOC's recent guidance on this issue?
Well, Aaron, that's a great question. And for the employers listening in who may not know, Title VII applies to employers who have 15 or more employees. So in the instance where an employer has fewer than 15 employees and where there are no state guidelines or state statutes on this topic, it may be that the employer doesn't have to comply with anything related to discriminating against same-sex individuals or against individuals who may have a different gender identity. That being said, we can never know what might change, right? We can never know how quickly these states are going to change their laws, and they do seem to be changing laws quickly. So the best guidance that any employer can have, even if that employer has fewer than 15 employees, is to always simply ensure compliance. And again, who knows when that employer may have more than 15 employees, right? Because at that instance, that's when compliance must then be mandatory. So of course, every employer is always encouraged, regardless of that employer's size, to be compliant, to take steps to be compliant.
A user by the name of Robin would like to know, should my company update our harassment training program to refer specifically to this issue?
Robin, that's a good question. It depends on what your harassment training program already says, right? Because we don't want to necessarily single out gay individuals or single out transgendered individuals, but it's always important that harassment policies or any policies be able to consider and be able to take into account discrimination of any kind. So if your policy already says we don't discriminate based on race or we don't discriminate based on marital status, absolutely. Put in there that you aren't discriminating based on sexual orientation or gender identity. It really depends on how the current policy is written. And of course, I'd suggest that you do talk to a labor and employment attorney in your state to help with drafting that.
And one final question. A user by the name of Karen would like to know if you have any thoughts or insights on whether ENDA, or the Employment Non-Discrimination Act, which is proposed legislation in Congress that's been proposed for many years in a row, whether that will ever become law, which would then modify Title VII to specifically include sexual orientation and gender identity as protected classes. Do you have any insight as to whether ENDA is going to be reintroduced or potentially passed anytime soon?
Sure. Hi, Karen. I don't have a crystal ball, and I always tell my clients, no matter what case I help them with, I don't have a crystal ball. I cannot predict the future. So I can't say whether ENDA is going to be passed or whether it's not going to be passed. But to be honest, it doesn't really matter at this point if we're looking at it from terms of including sexual orientation or including transgender people and that specific language in Title VII, whether or not ENDA is passed or if it isn't, because the default rules that we've already come to and then the way that the EEOC is now treating Title VII already includes sexual orientation, already includes transgender status. It's a de facto class. So it ultimately probably would have little effect in terms of that specific area.
That's all the questions we have at this time from the audience. Kim?
This concludes today's webinar. Thanks everyone for attending today's presentation. We hope you found this information useful in understanding the various legal issues associated with sexual orientation and gender identity in the workplace. Thanks again to Jessica for being our guest panelist. We look forward to continuing to work with Jessica on future presentations. And to all our attendees, thanks for choosing Personnel Concepts as your provider of workplace compliance solutions. Have a good afternoon, everyone, and a good day.